Good morning. Good morning to you all. Welcome to day 4 of Cornerstone Barristers Planning Week. Today, Emmaline Lambert, Ben Dufer and I will provide an overview of some of the most important decisions to have emerged from the courts in the last 18 months or so. For those who were expecting to see Richard Graham today, apologies, he can't be here. Instead, I shall attempt to fill his oversized shoes. The last day of our planning week tomorrow has 2 further presentations, one on plan making and the other on remote events, our experience of remote planning inquiries and hearings. And we hope you will join us for those. That's enough from me. Emmaline Lambert will begin the first part of the presentation.
Good morning and thank you, Robin. I'm going to talk about 4 Court of Appeal cases from the last 12 months, and unsurprisingly there have continued to be cases relating to the familiar themes of weight to policy, the tilted balance and 5-year housing land supply, and these cases all broadly fit within that theme. The first is Peel Investments, in which the Court of Appeal gave its judgment in September. And as you can see, this was about development on an important green space. Next slide, please, Ben. The developer, Peel Investments, had applied and been refused planning permission for 2 residential developments in 2013 and 2017. The local authority had adopted the Salford Unitary Development Plan in 2006, and it had an end date of 2016. The SUDP included policy EN2, which prohibited development which would fragment or detract from the openness of a strategically important green wedge. The supporting text to policy EN2 dealt with a specific area and provided that it was a strategically important green wedge and was of great strategic and local importance. And policy EN2 had been saved by direction prior to the policies of the UDP expiring. Next slide, please. In April 2013, the developer applied for outline planning permission of a development of up to 600 dwellings and other facilities, including a marina and other recreation provision. The application was refused by the council as it was contrary to policy EN2. An appeal to an inspector was dismissed, but the developer successfully challenged that, and the inquiry was then reconvened. In April 2017, a further application was made for residential development. This was also refused on the basis of conflict with policy EN2. At the planning appeal in 2018, the appellant contended that policy EN2 was out of date, relying on NPPF 2012, which was applicable at the time, particularly paragraph 14 and the presumption in favour of granting permission for sustainable development, where a local development plan was out of date, deemed to be out of date, where the local authority was unable to demonstrate a 5-year supply of land. The inspector found that policy EN2 was not out of date and should be given substantial weight. And in any event, the housing land supply exceeded 5 years, so the tilted balance did not apply. The inspector recommended that permission be refused. In between that report of the inspector and the Secretary of State making his decision, in July 2018, the revised version of the NPPF was published, containing the variation on NPPF 12, paragraph 14 in the form of paragraphs 11C and D. The Secretary of State, agreeing with the inspector's report, found that policy EN2 was not out of date, remained part of the development plan, and was not inconsistent with NPPF 2018. He also found that the local authority in any event could demonstrate a 5-year housing land supply, in fact, one of over 13 years, and that therefore policy EN2 was not impeding delivery of the necessary number of houses. He upheld the refusal of planning permission, and at first instance, the challenge was dismissed. In the Court of Appeal, the first ground was in relation to the effect of the expiry of the period of the development plan. It was found that a policy was not out of date simply because it was in a time expired plan. If the NPPF had intended to treat as out of date all saved but time expired policies, it would not have used the phrase out of date. Rather, the Court of Appeal said it would have used the language of time expired policies or policies in a time-expired plan. Next slide, please, Ben. It was also said that the key to interpreting paragraph 11D is to be found at paragraph 55 of the Suffolk Coastal Judgment, that whether a policy becomes out of date, and if so, with what consequences, are matters of pure planning judgment, not dependent on issues of legal interpretation. Peel Investments also had other grounds of appeal. One was that a plan without strategic policies, such as policies for housing supply, should be regarded as out of date for the purposes of paragraph 11D and the tilted balance. The court focused on policy EN2 and found that it was incorrect to characterise it as a freestanding policy when it was one of 104 policies in the UDP that had been saved. It said it was obvious that many policies would not expire with the plan, but would survive beyond the plan period. And it was pointed out that a policy which addresses environmental protection clearly has a life beyond the expiry of a plan. The last ground of appeal related to the impact of policy EN2, which had been considered by the inspector and then by the Secretary of State in response to an argument about restricting development in the area. The court found that the inspector was entitled to conclude that the policy was not impeding delivery of housing where the council was meeting its 5-year housing land supply. And again, this was a matter of planning judgment. Next slide, please, Ben. The next case is Oxton Farm and Harrogate Borough Council, which looked at the issue of whether it was lawful for the tilted balance to be applied by Harrogate Borough Council when it granted outline permission for 21 houses and a village shop on land outside settlement limits in the village of Bickerton. The officer's report noted that the proposal was contrary to various policies of the development plan, but still recommended that permission be granted, all on the basis of the tilted balance. Next slide, please. So was that lawful? Well, the officer had recorded that the policies setting out the annual housing provision and the list of settlements were out of date, as they were based on an old housing target. However, in July 2018, the council published its housing land supply update, which provided for a much higher housing requirement than that in the development plan, and its housing land supply was therefore 5.02 years and marginal. On the 20th of September 2018, 5 days before the permission was granted, the Office for National Statistics published its 2016-based household projections, which indicated that only 383 dwellings were needed annually in the area, and therefore the council's housing land supply was far more than the 5.02 years it had just published. Oxton Farm challenged the permission on various grounds, including that the officer had wrongly advised that the tilted balance was engaged on the basis that the housing land supply position was merely marginal and that the council had failed to take into account the effect of the 2016-based ONS projections, published days before the committee meeting, and which resulted in a deliverable supply of over 7 years. The Court of Appeal rehearsed that apart from considering the development plan, the local planning authority must also have regard to material considerations which may justify a departure from the development plan. Material considerations fall into 2 categories: those which the decision maker may take into account but need not, and those which the decision maker must take into account. The Court of Appeal quoted Mr. Justice Holgate in the Client Earth case this year, which we heard about earlier in the week. In short, the ONS projections were not required to be taken into account. The case then turned on whether the MPPF, a material consideration to which the local planning authority must have regard, had been interpreted correctly. And the Court of Appeal held inter alia, and there is more detail in the written paper, that firstly, the officer had not advised the committee that the tilted balance was triggered on the basis that the supply was marginal. In fact, the officer had advised the committee that the tilted balance was triggered because the most important policies for determining the application were out of date. Weight given to policies was, in accordance with well-established case law, a matter for the decision maker. And that following Eastleigh Borough Council, there is no basis for saying that a decision maker should increase the weight to policy due to the existence or surplus of a 5-year housing land supply. The NPPF allowed the council options for its housing land supply position. The council was entitled to rely on its proposed housing requirement in the emerging local plan, and it was not required to use the standard method in the NPPF. Next slide, please. The next case is Corbett and Cornwall Council. Cornwall Council's Planning Committee had permitted an application for the extension of a caravan park for holiday lodges within a designated area of great landscape value on the recommendation of a planning officer. And here is a picture of it. Next slide, please. At the time of the decision, the development plan consisted of the Cornwall local plan, together with saved policies from older plans. Policy 14 of the local plan stated that development that would harm an area of great landscape value would not be permitted, and there were no exceptions. Policy 23 of the Cornwall local plan was a landscape protection policy and supplemented Policy 14. However, Policy 5 of the core strategy promoted tourism and supported new tourist facilities. The council had found that the proposal caused limited harm to the area of great landscape value, contrary to Policy 14, but that the proposal was, in any event, in accordance with the development plan. The High Court disagreed with the council and quashed that planning permission and held that the planning application should have been refused as the proposal was contrary to Policy 14, causing harm to the area of great landscape value. It was also found that the reasoning of the council was inadequate. The Court of Appeal reversed that and set out that development plans contained broad statements of policy, and it was not unusual for relevant policies to pull in different directions. Next slide, please. The planning authority had to exercise its judgment to determine whether a proposal accorded with the plan as a whole, bearing in mind the relative importance of the policies at play and the extent of the compliance or breach. Interpreting the relevant policies depended on a sensible reading of their language, both in their context and together. A challenge could only be made on the grounds of irrationality or perversity. None of the policies had primacy over the others. There was no order of priority indicated. The main factors on either side of the argument were the benefits of the development in furthering Policy 5 and tourism, and the extent and significance of the breaches of Policy 23 and 14, protecting landscape. An appropriate balance, the court said, had been struck. But it is worth noting that Lord Justice Lindblom did clearly consider that a breach of a single policy could give rise to a breach of the development plan as a whole. Next slide, please, Ben. And lastly, the case of East Bergholt Parish Council, who challenged 3 grants of planning permission for 229 houses on the basis that the local planning authority had incorrectly calculated its 5-year housing land supply and had relied on a less favourable supply. It argued that the council had misapplied NPPF policy and had included only sites on which it was certain or absolutely certain that housing would be delivered within 5 years. In particular, sites without planning permission were only considered deliverable if the council had resolved to grant planning permission with a planning obligation. It argued that 14 planning applications had been discounted from the supply pipeline, which, if included, would result in a 5-year housing land supply. The parish council also alleged that the council had taken into account the financial costs of defending appeals in granting the planning permission. Next slide, please. At first instance, the case was dismissed and the appeal to the Court of Appeal was also dismissed. It was found that sites that were not certain to be delivered could be included in a 5-year housing land supply, but the whole issue of assessing deliverability was replete with planning judgment and must always be sensitive to the facts. And in what has become very familiar, warned that the court will not intrude into the territory of planning judgment, which is the exclusive domain of the decision maker, nor will it subject the decision maker's own exercise of planning judgment to review beyond the range of public law. The parish council had also argued that the local planning authority had wrongly taken into account the financial consequences of fighting appeals when assessing housing land supply. There had been mention of costs of appeals, but the Court of Appeal considered the officer's report to Planning Committee, minutes of 3 committee meetings, and the annual monitoring report, and found there was no evidence to suggest an approach by the council of avoiding the financial implications of appeals, and nothing to suggest that such a consideration had influenced its assessment of housing land supply. It said that the district council made its decisions to grant planning permission lawfully, with a true understanding of relevant policy and on the strength of land use considerations that were material. It did not resort to considerations that were immaterial. Thank you very much. And now I hand over to Ben.
Thank you, Emmaline, and good morning, everybody. I'm going to talk to you about 3 cases today. Firstly, 2 neighbourhood plan cases, the first of which is a vehicle really to introduce a few neighbourhood plan challenge themes that will occur in this sort of litigation, and the second is a recent example of a successful neighbourhood plan challenge which I was involved in. The third case I'm going to talk to you about is a recent judgment of the Court of Appeal in the last month or so about planning conditions. So Wilbur first. In Wilbur, Mrs. Justice Lang reviewed and helpfully summarised the approach to be taken in challenges to neighbourhood plans, and anyone involved in such a challenge or considering such a challenge would be well advised to review Wilbur, because it sets out a framework against which those sorts of challenges is likely to be tested. As many of you will know, neighbourhood plans are drawn up in a different way to local plans, and rather than being examined for soundness, they are examined and tested against the basic conditions. These are set out in paragraph 8, subsection 2 of Schedule 4B to the Town and Country Planning Act 1990, and they include that having regard to national policies and advice contained in guidance issued by the Secretary of State, that's of course the PPG, it's appropriate to make the plan. That's condition A, and condition E is that the making of the order or plan is in general conformity with the strategic policies contained in the development plan for the area. There are other certain matters set out in the basic conditions, but I don't repeat them all now. And as I said, these are the conditions against which an independent examiner will consider a neighbourhood plan and may either recommend it for referendum with or without modifications to it if they're necessary, or recommend refusal of the plan. And that recommendation goes to the council to consider for itself the question of whether the basic conditions are met. If the council is satisfied that the basic conditions are met, the plan then proceeds to a local referendum. And if a decision is to be challenged along the way, it's very important that the timing of that challenge is right, because Section 61N of the Town and Country Planning Act prescribes various time limits for the challenges to different stages of the neighbourhood plan process. And in Wilbur, as in the Lockerlaw case, which I'll talk about in a moment, the challenge was made pursuant to subsection 2, so 61N subsection 2, which concerns proceedings for questioning a decision as to whether the plan should proceed to referendum. And there are other stages at which various other aspects of the neighbourhood plan process can be challenged. The judgment in Wilbur stresses the following points, which are of general application to neighbourhood plan challenges. Many of them are familiar public law territory, or certainly planning law territory, but it's a good example of them being applied in the neighbourhood plan challenge context in that discrete statutory framework that there is for the challenge of neighbourhood plans. So of course it's a judicial review, and the claimant must establish that the defendant has misdirected itself in law or acted irrationally or failed to have regard to a relevant consideration, or maybe there's some procedural impropriety. But of course, as Emmaline mentioned in her cases, the planning judgments are for the decision makers, and the courts will be alert to the risk that a challenge is being used, as Mrs. Justice Lang described, as a covert way of impermissibly reviewing the planning merits. Mrs. Justice Lang also explained that the function of the local authority under the paragraph of Schedule 4B is to consider the examiner's recommendations and the reasons for them, and to satisfy itself that the draft plan meets the basic conditions, but that the local authority doesn't need to duplicate the work of the examiner, and that the examiner's report may, depending on the circumstances, provide a sufficient basis for the local planning authority to properly conclude that the plan meets the basic conditions and other statutory criteria. So in other words, it doesn't need to redo everything that the examiner has done. It can use that as part of its, an important part of its decision making, if the examiner's report is sufficiently robust. And the consequence of that is that although technically the challenge is to the decision of the council, often what will be important in these challenges is the contents of the examiner's report. And Mrs. Justice Lang explained that the principles applied to decision letters of inspectors in Section 78, Section 78 inspectors' decisions should also be applied to examiners' reports. So an extension, like we see other cases where they're applied to officers' reports to committees, they should also be applied to examiners' reports. And that means reading the report fairly as a whole and in good faith and in a straightforward manner. Mrs. Justice Lang also applied the presumption set out by Lord Carnworth in Hopkins Holmes that specialist planning inspectors will have understood the policy framework correctly, and starting from that presumption, Mrs. Justice Lang thought that that presumption should apply also to neighbourhood plan examiners. That was also an issue in the Lockerlaw case, which I'll go on to mention in a moment. And in the Court of Appeal, that point was also agreed within Lockerlaw. So no doubt really that that presumption is to be applied not only to Section 78 decision letters, but also now to neighbourhood plan examiners' reports. And that framework will be the same for any similar neighbourhood plan challenge, and that is the framework against which those challenges are likely to be assessed. In Wilbur, when Mrs. Justice Lang went about applying those principles to the challenge in question, which concerned the evidence base and reasoning in respect of a proposed gap policy in the particular neighbourhood plan, she was satisfied that the council's decision that the plan met the basic conditions was without legal error, and therefore upheld that decision. The next case I'm going to talk to you about is the Lockerlaw one, case which Richard Ground and I were involved in and acted for Lockerlaw. The case concerned the draft Norton St Philip neighbourhood plan, and in particular policy 5 of that plan, which sought to allocate 10 parcels of land in Norton St Philip as local green space, and 2 of those parcels of land belong to our clients. Local green space is a term of art, and it is essentially defined in paragraphs 99, 100 and 101 in the NPPF. The draft plan had been examined by a neighbourhood plan examiner who was satisfied that it met the basic conditions, and she discussed policy 5 a little bit. And the local authority had agreed with her conclusions. as I have already mentioned, one of the basic conditions is that having regard to national policy, it's appropriate to make the plan, and that is the basic condition on which this challenge turned. The Court of Appeal accepted our submission that a statutory requirement of this kind, so one where you have to have regard to national policy and be satisfied that it's appropriate to make the plan having regard to that national policy, a statutory requirement of this kind requires the decision maker not only to take those national policies into account, but also to observe them and to depart from them only if there are clear reasons for doing so. And in my view, that is likely to be the most important aspect of this judgment. Indeed, I'm already aware of neighbourhood plan examinations which are going on around the country where the implications of the judgment are being considered, and where inspectors are asking, neighbourhood plan examiners are asking, particularly with relation to this judgment, exactly on that point, whether if there is any conflict or departure from those national policies, whether there is a justification for any such departure. And supplementary questions I've seen being asked on the issue. The judgment also confirms in this regard that there's a statutory duty on neighbourhood plan examiners and ultimately on the local authority to recognise in their decisions any departures from national policy, and only to approve such departures if there are clear reasons for doing so. This, of course, doesn't mean that there cannot be a departure, but those departures must be explained and considered. In this case, the departure which we had identified was from paragraph 101 of the MPPF, which requires that policies for managing development in a local green space should be consistent with those for green belts. And the Court of Appeal held that the word consistent should be given its ordinary meaning, and that this meant that national planning policy provides that policies for managing land within a local green space should be substantially the same, the Court of Appeal said, as policies for managing development within the green belt. In our case, the draft policy read, development on local green spaces will only be permitted if it enhances the original use and reasons for the designation of the space. And our point was that the wording of the policy is overly restrictive. Even though Greenbelt policy is a very restrictive designation, the draft policy which the neighbourhood plan had come up with was even more restrictive than Greenbelt, because it didn't allow for development, say, in very special circumstances, and didn't provide the sorts of not inappropriate development categories which are set out in national Greenbelt policy. And the Court of Appeal accepted these submissions, concluding that there was a gaping hole in the examiner's reasoning in this regard, and quashed, therefore, the local authority's decision, because whilst there was a gaping hole in the examiner's reasoning, the local authority also hadn't grappled with the issue. And so the matter is now back with the local planning authority to consider the necessary amendments to the proposed green space policy to ensure that that policy is consistent with national policy for green belts. And there are two other matters just worth mentioning about this case. Firstly, we obtained an interim injunction to prevent a referendum on the neighbourhood plan happening before the judicial review had been disposed of. And that was obtained at all stages of the litigation, and the paper gives reference to the initial application and decision in that regard. And secondly, to my knowledge, it was the first planning case which was heard remotely, both in the High Court, which happened in March, and the Court of Appeal in July. The decision in the Court of Appeal was expedited because there was the interim injunction in place. So those are the two neighbourhood plan cases, and the next thing I am going to turn to is planning conditions. This is the famous or perhaps infamous magic roundabout in Swindon. The case I'm going to discuss doesn't have very much, if anything, to do with the roundabout, but it is about a development site in Swindon, and it is about highways, so perhaps a tenuous link, but there we are. DB symmetry. DB symmetry. The issue on this appeal was whether a condition attached to the grant of planning permission for employment development of various kinds was lawful. The inspector had said no, it wasn't. The High Court had said yes, it was, and the Court of Appeal ultimately, as we'll see, agreed with the planning inspector. The application concerned part of an area referred to in the local development plan as New Eastern Villages, and it was a strategic allocation to deliver economic and housing growth on the outskirts of Swindon, including 8,000 homes and 40 hectares of employment land, and this application was part of that wider development. And attached to the outline grant of planning permission were 50 conditions, and the appeal turned on condition 39, which is set out in the paper and reads: the proposed access roads, including turning spaces and all other areas that serve a necessary highway purpose, shall be constructed in such a manner as to ensure that each unit is served by a fully functional highway, the hard surfaces of which are constructed to at least base course level prior to occupation and bringing into use. And the dispute between the parties was whether the condition required the developer to dedicate the roads as public highways, and that was Swindon's contention, or whether it merely regulated the physical attributes of the roads, and that was the developer's contention, supported by the Secretary of State. The developer had, on appeal, successfully obtained a certificate of lawfulness pursuant to section 192 of the Town and Country Planning Act, that the formation and use of access roads as private roads without dedicating those roads as public highways would be lawful and in accordance with that condition. And this appeal was in respect of that grant of certificate. This challenge was challenged by the local authority against that grant of certificate. And in paragraphs 22 to 27 of the judgment, there's a useful summary of the relevant law in relation to highways. I don't intend to set it all out now, but it explained that the way in which a highway comes into existence is through dedication and acceptance by the public, and it looked at the mechanisms in which dedication can take place, whether express or inferred from public use, and noted that depending on the circumstances, a highway may be repairable at public expense, repairable by a landowner, or there may be no liability at all to repair it. The judgment also noted the various statutory mechanisms available for the creation of a highway under, for example, provisions of section 38 and 278 of the Highways Act. A highway authority may arrange for the construction of a road at the developer's expense, followed by dedication of that road as a highway repairable at public expense, or alternatively, the carrying out of works prior to the adoption may be carried out by the developer, commonly under a section 106 agreement, and section 263 of the Highways Act provides for the vesting of highways in the highway authority. None of that happened in this case. In this case, there was simply that condition that I've already recited. The Court of Appeal explained that there's a recognised difference between what can be achieved by conditions on the one hand and what can be achieved by planning agreements or planning obligations or other statutory mechanisms on the other. And it was explained that the direction of travel in planning legislation has been to encourage a wider use of planning agreements and obligations while leaving the scope of the power to impose conditions untouched. And the Court of Appeal suggested the reason for this is that unlike conditions, planning obligations cannot be imposed unilaterally, and therefore there needs to be developer consent with planning obligations. And absent that consent, the local planning authority may refuse permission. And the Court of Appeal was satisfied that a case of Hall of some vintage remained good authority for the proposition that a condition that requires a developer to dedicate land which he owns as a public highway without compensation would be an unlawful condition. The consequence of that would mean that if that were the proper interpretation of this condition, unless the condition could be severed from the planning permission wouldn't be allowed to stand. And the court therefore considered whether that was indeed the proper interpretation of the planning condition by asking itself the familiar question of what a reasonable reader would understand the words to mean when reading the condition in the context of the other conditions and the consent as a whole, undertaking that familiar objective exercise in which the court has regard to the natural and ordinary meaning of the relevant words, the overall purpose of the consent, and any other conditions which cast light on the relevant purpose of the relevant words, and with regard to some common sense. One aspect of this judgment, which I think is worth noting, is that the Court of Appeal applied a principle called the validation principle to the interpretation of this planning permission, and that is a principle which is commonly applied to the interpretation of other documents, and it means that the court will prefer an interpretation which results in the clause or contract being considered being valid as opposed to void. It's an approach which is triggered when the court is faced with two realistic interpretations, as it was here. And the Court of Appeal was satisfied that the inspector's interpretation of the condition was at least realistic, and applying the validation principle therefore agreed with the inspector, who had found that the condition simply imposed a requirement concerning the manner of the construction of the access roads, requiring them to be capable of functioning as a highway along which traffic could pass, whether private or public, but did not require the construction of access roads to be made available for use by the general public afterwards. There's detailed analysis in the judgment at paragraph 77 to 87 in support of the inspector's conclusion, and I've summarised that in the paper, but I don't intend to set that more detailed analysis out now. Just recapping very shortly, the case is a good example of the proper approach to the interpretation of conditions confirmed in Trump and Lambert cases in the Supreme Court, and those principles being applied. And it's also a useful reminder of the need to be careful when it comes to the mechanism used to secure dedication of public highways. And as I've said, it's also an interesting example of the validation principle being applied. So 3 things to take from that case. And I'll now hand over to Robin, and apologies, Robin, for slightly running over my time.
Well, Ben, thank you very much indeed. I'm going to talk about first Finney and the Welsh ministers, and the slide there shows the relationship between the size of a wind turbine and the power output. And as one can see, a relatively small increase in turbine size can result in a substantial increase in power. And the more power is produced, the greater the return to the developer, which explains why the case of Finney and Welsh ministers made its way to the Court of Appeal. I'll now ask my glamorous assistant for the next slide, please. Thank you. In that case, planning permission had been granted for 2 wind turbines with a tip height of up to 100 metres. And the point to note is that the reference to a tip height of up to 100 metres appeared in the description of the development permitted. There was also a condition that required the development to be carried out in accordance with the approved plans, one of which showed a 100-metre tip height turbine. The promoter decided that it wanted larger turbines, and so it applied under section 73 for a permission, but with different conditions. It sought a permission for turbines with tip heights of 125 metres, and that application was considered and then refused by the local planning authority. Next slide, please. That refusal went to an inspector. The inspector considered that the increase in tip height from 100 metres to 125 metres didn't give rise to any significant planning objection, and so she granted planning permission for the installation of 2 wind turbines, but in the description of the development permitted, she did not mention the tip height. The permission also included a condition requiring compliance with approved plans, and in that case, the different approved plan showed a 125 metre tip height. Next slide, please. That planning permission was challenged all the way up to the Court of Appeal on the ground that Section 73, which permits the grant of planning permission without complying with conditions previously attached to a permission, didn't allow an inspector in this case to grant planning permission for development with a different description of development. All it permitted was a change to the conditions. That challenge failed in the High Court, but in the Court of Appeal it was held that this was correct. Section 73 is concerned simply with changes to conditions. There's nothing in it that allows the description of development in the original permission to be altered. That's its sole purpose. And that was a matter of straightforward statutory construction, although there had been, it's fair to say, some High Court decisions before that that suggested that perhaps Section 73 wasn't as confined as that. As a result of the court's interpretation of Section 73 and its limits, it held that the inspector's decision was ultra vires and therefore had to be quashed. Next slide, please. Alive to the fact that developers, promoters might well want to obtain a fresh permission with a moderate variation in the description as well as a change to conditions, the court suggested that if in a case like this, there is a need to change the description of the development permitted, Section 96A of the 1990 Act might allow it. That allows non-material amendments to planning permissions, and it may be possible in certain circumstances to seek to amend the description of development to exclude, for example, the parameter that wants to be changed. So either the tip height in this case or the number of dwellings, something like that. If that wasn't possible, if the change was considered to be material, then the court made it clear, well, the only alternative then was to seek a fresh planning permission. Next slide, please. The second case, that of Samuel Smith Old Brewery and North Yorkshire County Council, concerns the interpretation of openness in the Greenbelt. That's an aerial view of a quarry extending to about 25 hectares in area, and the case concerns an application to extend it by 6 hectares. Next slide, please. The quarry happened to be in the Greenbelt, and obviously one of the issues was whether or not the 6 hectare extension would have an adverse impact on openness. It's been Greenbelt policy for many years that mineral extraction in the Greenbelt is not necessarily inappropriate, provided it preserves the openness of the Greenbelt and doesn't conflict with the Greenbelt objectives. In that case, it was argued that the subsequent grant of planning permission by the local planning authority was flawed, because in the officer report, which was an extensive and detailed document, the officer had incorrectly approached, had too narrowly approached the issue of whether the extension would preserve the openness of the Greenbelt. Next slide, please. In the officer report, the issue of openness had been treated as essentially the absence of built development. And the officer had not, in that context, taken account of the, albeit limited, landscape impacts that the proposal would have on the landscape, something that had been addressed elsewhere in the report. Well, that case made its way to the Court of Appeal, where Lord Justice Lindblom, given the judgment of the Court of Appeal, accepted that the officer had erred in his approach. Lord Justice Lindblom indicated that landscape impact, visual impact, was an aspect of openness, and the officer had unlawfully failed to include that in his assessment. And the case then went to the Supreme Court, where Lord Carnworth, not for the first time, gave Lord Justice Lindblom a metaphorical kicking. Next slide, please. In that case, Lord Carnworth went back to first principles. The law does draw a distinction between material considerations that a decision maker has to take into account, because, for example, a statute expressly or implicitly requires it, or because the consideration is so obviously material that it would be irrational to leave it out of account. That's one type of consideration which has to be taken into account. Another type is one that may be taken account, that is capable of being relevant, but it's a matter of judgment whether the decision maker has to take it into account or not. Looking not simply at the NPPF, but earlier iterations of Greenbelt policy, Lord Carnworth concluded that policy, both in the NPPF and before, did not require a decision maker in assessing the effect of development on openness to take account of the visual impact of development in assessing that effect. Next slide, please. It was made clear by Lord Carnworth that visual impact was one of those considerations that could be taken into account, but didn't have to be. Whether it should be taken into account in any particular case was a matter of planning judgment. And on the facts of that particular case, the quarry extension was found to have only a very limited visual impact, beyond that already caused by the existing quarry. And it wasn't one of those cases where that visual impact was so obviously material that the decision maker, the local authority, had to take it into account. And so it was held that the grant of planning permission was entirely lawful. Next slide, please. That brings me to the third and final case I'm going to speak about, that of David Gathercole and Suffolk County Council. As you will all immediately have recognised, that is a Lockheed Martin F-35A Lightning II, a very expensive piece of military equipment and very noisy. And the noise from it was central to the case, involving, I have to say, two of our very own top guns, Richard Ground, call sign Lunch, and Jack Parker, call sign Frenchy, who triumphed in the High Court and indeed in the Court of Appeal in their dogfight. Next slide, please. In that case, planning permission had been granted by the County Council to itself for a primary school and preschool just outside the village of Lakenheath, and RAF Lakenheath happens to be where the United States Air Force maintains, I think, its largest base in the United Kingdom. The primary school was needed because the local planning authority had resolved previously to permit up to, I think, 663 new dwellings to be built in the village, and the existing primary school was very much close to capacity. So a new primary school was needed. The question was, where should it go? Next slide, please. The application had been supported by an environmental statement. That was also an extensive document, and that dealt with a variety of environmental matters, including the availability of alternative sites and the issue of excessive noise, And it touched on the fact that there would be children with hearing problems, with communication difficulties, who would be perhaps particularly affected by the noise from aeroplanes flying overhead when they were either working or playing outdoors. A challenge to the grant of planning permission was brought on several grounds. It ended up ultimately in the Court of Appeal, and two issues were decided by the Court of Appeal. The first was whether or not there had been a failure by the local authority in granting planning permission to comply with its public sector equality duty to give due regard to the interests of children with protected characteristics. And the second issue is whether or not the environmental statement had dealt adequately with, if you like, the environmental characteristics of the alternative sites. Next slide, please. The Court of Appeal accepted that there had in fact been a breach of the public sector equality duty. The issue or the concern had been raised in the environmental statement about the effect on children with protected characteristics, but it hadn't featured in the officer's report, and there was no proposed method of mitigating that effect. So the court held, yes, there had been a breach of the duty, but the court went on to refuse relief, relying on section 31(2)(a) of the Senior Courts Act 1981, on the grounds that it was highly likely that even if the public sector equality duty had been met in full, even if the officer's report had dealt with at some length with the concern, planning permission would still have been granted. The simple fact was that the proposed school was less noisy than the existing primary school, and no better site had been found for a new primary school. It had been argued by the challenger in that case that section 31(2)(a) was limited to what are essentially procedural or technical errors, not errors going to the substance of the decision. The Court of Appeal, in the guise of Lord Justice Coulson, rejected that. The power exists, he said, to essentially avoid the waste of time and money that would occur if you required a decision maker to retake a decision where it's highly likely that the decision would be the same as the earlier one. Next slide, please. As to the allegation that the environmental statement hadn't dealt adequately with the environmental qualities or characteristics of alternative sites, that was rejected. It was clear from European case law that although environmental information about alternative sites was required to be given, that did not have to constitute an environmental assessment in relation to each of those alternative sites. And whether or not an environmental statement dealt adequately with alternative sites was ultimately a matter of judgment for the local planning authority or an inspector on appeal, and that would be subject to ordinary Wednesbury review. In that particular case, the court was unimpressed that that aspect of the challenge hadn't been raised by anyone before the judicial review had been launched. And in the court's view, although the treatment of alternative sites had been fairly cursory, it had been sufficient. And in those circumstances, the court rejected the challenge. Next slide, please. That brings us to the questions section of this presentation. And I have one question from Patrick Atherton. I'll read it out. It asks, if agricultural land is protected from residential development by an adopted in-date local plan and neighbourhood plan, on what basis can a planning application for housing development claimed as enabling development for a school override the protection policies? Is there case law for this principle? I will attempt to answer that by simply saying this: whatever protection is given by a development plan at whatever level, it can always be overridden if there are sufficient material considerations to justify a departure from it. It's said in the example given that the housing development might be enabling development for a school. if the need for the school was sufficiently great, and whether it's sufficiently great is a matter of weight for the decision maker, then that may well justify overriding the protection given by policy in a development plan. Or at least that's my view. I don't know if Ben or Emmaline have any other comments to make.
No, thank you, Robin. I agree with that.
I agree.
We have 3 more minutes. If there are any more questions, please do send them in. I get the sense that that's the only question we're going to have today. And so I think it right, we are just about at the end of the hour. I think it right to wrap up this presentation, to thank you all very much indeed for joining us. We very much hope you found the cases selected interesting and our presentation enlightening, and possibly on occasions even entertaining. Anyway, from Emmaline, from Ben and from me, thank you very much indeed.
Thank you.
Thank you.